This is Brandon Stallings. All right, this is Brandon Stallings, Board of Trustees, Chair of the Ad Hoc Commission on the the Discipline System. I want to call this meeting to order, and if we could have Ms. Chavez, our illustrious staff member and hardworking staff member, take roll.
Okay, terrific. Okay, I just wanted to take a moment to look into the attendees list to see if any of our commission members are there. So I can promote them. Let's look. I see people still trickling into the attendees. So let's take a minute. Okay. No one there. Okay. I'm going to take roll. 3-1. Anderson. Bell.
Here.
Buenaventura.
Present.
Buffington.
Present. Thank you, Ms. Chavez.
Chen. Chen. Duran. Rashadi.
Here.
Farwell. Good.
Present.
Jones.
I'm here.
Joseph. Oh, Jones.
Was that Jones?
Yes, yeah, Jenna Jones.
Yes, I'm here. Thank you.
Thank you. Joseph.
Here.
King.
Here.
Larkin.
Here.
Lawrence. Lear.
Here.
Mayorga. Mayorga. Okay. Judge McGill. Let me just see if he's in the attendee list by any chance. Nope. Okay. Moana.
Here.
Nakau.
Here.
Pansky.
Here.
Rosenblatt. Okay. Schneider.
Yes, I'm here.
Okay. Selig. Wang.
Present Lisa and Judge
That's right.
McGill.
That's right.
Present Lisa and Judge McGill apologizes for not being able to appear today. He's out of the country.
Okay, terrific. Thank you. And Winfield. Okay. And Stallings.
Present.
Okay, great. Okay, Chair, you have a quorum at 16 members
All right,
present.
perfect. Thank you, everyone, for what should be a wrap-up meeting of the Ad Hoc Commission. Thank you for being available today, especially so close to the holiday season. I know that everybody's schedules get a little bit more compressed the later we get into the year. So thank you for your presence, but not only that, for your review of all the documents that were just sent to you. Before we get into the discussion, though, I will make a call for public comment. And so if you are appearing on the Zoom meeting, please raise your hand. The staff person, in this case, Ms. Chavez, shall identify you. And once you've been identified and are given the microphone, you'll have 3 minutes to make comment. So Ms. Chavez, are there any individuals who wish to address this board by way of raised hand?
Okay, I don't see any raised hands at this time, but let's give it another 10 seconds, 15 seconds.
And if there are any phone callers who are calling into the Zoom call, there is a function by which you can raise your hand. So if you are on the phone, please raise your hand by using that function.
Okay. Okay, Chair, I don't see anyone with raised hands in the attendees list. And I also just want to share out that the State Bar now has a new policy with regards to public comments. We give people an opportunity to submit public comments 24 hours in advance through an email to me. And I did not receive any emails for this meeting. And we also had a new process where people can sign up to give public comment. We did have one person who signed up. And so if that person, the person's name listed was Rico. So if Rico is in the audience, you can raise your hand and we can promote you. Okay. So no, I don't see any raised hands.
All right, great, thank you.
Mhm.
All right, I want to get right into the business at hand. And so I'm going to hand this over to Ms. Chavez.
Okay, terrific. Okay, everyone, I'm going to share my screen. And the purpose of this presentation is to just give it a little overview of where things are for now. Okay. So here's our roadmap. Starting here on the far left, in September 2022, Brandon and I presented your final report to the full Board of Trustees. At that point, they submitted all recommendations out for a 60-day public comment period. That period took place over the next few months, and it closed on November 28th. And staff compiled all public comments received and prepared a report for you that was attached to the agenda for today's meeting. We also attached a memo, and the purpose of today's meeting here in December is to review those public comments and to consider whether you should modify your existing recommendations or create new ones based on, again, on public comments. And then we will also then update the report to submit in January to the Board of Trustees. They will receive your updated report with any new recommendations, modifications, as well as the public comments themselves and the staff memo that we prepared. So the report will be updated regardless of whether or not you approve any new recommendations. We need to attach the public comment report and et cetera. And in January, the Board of Trustees will receive your updated report and any new recommendations, if any. So that's the roadmap going forward. And so again, so the purpose of today's meeting is to review the public comments and to consider whether or not you want to come up with new recommendations or modify your existing ones. So here's the agenda in particular. So first, I'm going to just do a little overview of a summary of the public comments received. And then we have 3 items. One is to discuss any potential new recommendations, discuss any modifications, and discuss next steps. So here's a summary of the public comments. So just a really big picture, the State Bar, the Board of Trustees put out your recommendations for a 60-day public comment period. This is standard procedures for the Board of Trustees to engage public comment on any of their actions that they're planning on. And we received 78 responses. 54 of them, those responses were from attorneys. And respondents were asked to vote essentially on recommendations. And they were given an opportunity to write comments to each one of those recommendations. And these are the 3 options when they quote unquote voted or gave their opinion on a recommendation. One is just straightforward, they agree only if modified, they agreed with the proposed recommendation, or they disagreed with the proposed recommendation. So staff prepared a memo for you that summarizes the results of the votes for each one of the recommendations. And it also identified comments that for you to consider for new recommendations. And then there's also a report that we attached to the agenda item that
Lisa, if I could just ask all members to check to see if they're on mute. And if you're not speaking, if you could just put your microphone on mute, appreciate it.
Okay, thank you. Thank you. And then there's also a report that contains all the public comments that we received, and they're organized by recommendation, further organized how people voted according to one of the 3 options. We also contain names. If people provided their names, people are allowed to submit recommendations or comments anonymously, and organizations, if they identify those organizations and said that they were speaking on behalf of an organization. And we also include links to attachments that people were allowed to submit attachments in support of their ideas, of their thoughts, etc. And so we included those as well. So when you go through the document, you see a live link, that's a link to a document that they submitted as part of their public comment. So here's a summary of each of the 9 recommendations. We split out recommendation 4, which has to do with the timelines. We split it out to ask people about their thoughts on the timeline for removing discipline history from website versus expunge it from the discipline record, because those are actually 2 different, even though they're meant to work together, they're 2 different processes, business processes. So we split those out. And ultimately, what you should gauge from this summary here is that all nine recommendations received the vote of agree with proposed recommendation as a majority vote. So that's this blue category right here. As you can see, for every recommendation, it's the biggest choice. There was variation, however, with the attorney representation receiving the biggest share of agree with the proposed recommendation at 81%, whereas the 2 items with regards to timelines, actually, they had lower levels of support, but still the majority supported this. And instead, what you see is you see the biggest share of people saying, I agree with this, but only if modified. And this is where you go to those comments and see what they have to say about this. And that's why we organize the comments that way. So you can see of everyone who said that they agree with the modified, what do they have to say about this item? Another standout here is with regards to the recommendation regarding sanctions. 21% disagreed with the recommendation to propose statute to explore statute to eliminate disciplinary sanctions. Okay, so does anyone have any questions before we move on about the memo? The public comments, the process, and the report that we shared with you. The report itself with all the list of comments.
I do, Ms.
Okay.
Chalice.
Yeah.
So the report that was shared broke out attorney respondents, or at least those that you were able to identify as attorneys, and gave overall. But I did not see a list of percentages for people who were members of the public or non-attorneys and what their positions on those were. I just saw the overall, which included the attorneys, and then the attorneys broken out.
Yeah, the reason why we chose not to have a category for those who are not attorneys is because of quote unquote not attorneys, the members of the public, is because so many people a lot of people skip the question, are you an attorney or not? So we can't say with confidence who are people who are not attorneys. Does that make sense? So, right, so we only identified attorneys for those that we are confident that they are attorneys because they either self-identified or, as I said in the memo, we saw their work affiliation and their email address, and then we confirmed in our own independent sources that they were an attorney. So that's the reason why. That's the reason why we did not have another line of data there for non-attorneys, because we don't know who's really a non-attorney in the data. So thank you, Steve, for reminding me, though, that one consistent finding, as you see in table 1 of the memo, is that attorneys tended to be more in favor of these recommendations than the group overall. Okay, Mr. Larkin. Okay.
Mr. Larkin, I think your audio is not coming through.
Better here?
There we go.
Thank you. I had the same comment or question that Steve did, but beyond that, I was really interested in the responses themselves, and they caused me to wonder who was motivated to file these responses. It seemed like there were a lot of the lawyers were those who had process involvement, so I understood that. And I then thought, well, isn't there a larger population of lawyers who might have something to say, but they just weren't, either didn't have opportunity or didn't take opportunity to respond. The public on the other side, some of those got pretty testy as to things like the Girardi case and the other, and some of them were just intemperate. I kind of wrote those off, but I'm just trying to get a better sense of the breadth of the invitation and why it seemed to me that we were getting really not polarized, but very hardened thought here on both the lawyer side and the public side, in my view.
So Lisa, do you want to break out a little bit more some of the info that was contained in the staff memo about the outreach that the State Bar did to try and get members of the public to make comment?
Sure. So, Mr. Larkin, getting the public to comment on our items that we put out for 6-day comment is just an ongoing challenge for the State Bar. And so we've really engaged in several strategies this time around because we knew it was really, really important to get the public comment on these items in particular. So something that was new was we created this mini site that I put a link to there. We even put that in, translated that into Spanish. And we engaged in a lot of social media posts in lots of different social media platforms such as Facebook, Instagram, LinkedIn, and Twitter, in order to reach out to people and to alert them to the existence of the comments and invite them to participate. And then finally, staff emailed around 80 community-based organizations to encourage them to reach out to their members to review and comment.
Thanks. It's very impressive, but at the end, it still is interesting as to what we got back as comments and how they tended to fall into baskets. And the number, of course, we're not trying to have a statistically reliable analytics here. We're looking at comments of those who happen to care enough, despite the wonderful outreach, to provide comment. So I just add that as my reaction to it all, but very impressive.
I would say, Jerry, you might not be used to public comment here in California, but in terms of being polarized and falling into camps, I think that's pretty common. Perhaps, unfortunately, but
And,
That's
and Ms.
right.
Wilson, and Ms. Wilson and Ms. Chavez, I don't know if you have, if you can comment on this, but you know, the ad hoc commission's work compared to other initiatives taken up by the state bar, would you say that this generated more or less public comment than other kind of similarly situated items?
I think this is a little bit less public comment than I would have expected. Less comment number in raw numbers. You know, the last effort this is coming off of, though, is the paraprofessionals, and that generated, you know, over 1,000 comments. So that was unusual. So that's probably not a good benchmark. Sometimes we get very little on this. I would have thought we would have gotten a bit more.
All right, any other questions for staff at this point in the presentation? All right, Mr. Lear.
Hello, everyone. Good to see you. My comment on the summary, which I thought was well done, is that it despite the breakdown, nevertheless, it overwhelmingly supports the good work that we've done and the recommendations that we have. So I think in that regard, my ultimate conclusion will be that it's basically proof of concept, and we move forward. But I'll let the meeting continue. Thank you.
Great, thank you. Any other questions for staff at this point? All right, Lisa, if you want to go ahead and continue.
Yeah, I will. Let me just lower Mr. Lear's hand and just acknowledge that Michelle Anderson has joined the meeting, so I've counted her as present. Yeah. All right, let's go back. Okay, so the next item is the potential new recommendations based on public comment received. And so I'll hand it over to you, Brandon.
All right, so hopefully everybody here has had a chance to review the document prepared by Lisa. And in that document, there are a number of new ideas or some new concepts that that commenters identified and that Lisa summarized and put into this report. And in thinking about these items, and certainly in discussion with Ms. Chavez, I think there's a consensus that these are some very good ideas, and these are some interesting concepts to look at. And what I wanted to do is kind of get a temperature from this group on whether there was any strong objection or strong offering of support for any of the new areas identified. And the thought would be, and we'll have a resolution here at the end of the discussion, but the thought would be to write a letter or submit this report to the full board of trustees with a request that a smaller working group perhaps be established, and that working group could be comprised of members of the ad hoc commission, maybe individuals who have identified interest in particular areas, and certainly there can be some outreach in regards to that. But the thought is that these are good ideas. We don't want to let them go by the wayside, but we do really want to conclude the work of this full commission, understanding that this 26-member body sometimes is difficult to get everybody together for meetings, and but we don't want to let these good ideas go by the wayside. So Are there any strong thoughts one way or the other about that approach to these new areas identified? Okay, seeing none. All right. Lisa, do you want to go through those specific new areas of I guess ways that the state bar could change the discipline system?
I'm sorry, Randy, so you want me to proceed with the presentation or are you? I'm sorry.
Yeah, proceed with the presentation because we're getting into the new areas identified. Is that correct?
Yes, but I thought we were going to talk about the possibility of everyone just like before we go through all. Is it the idea we're just gonna like just overview them briefly and then have like make a decision like the path forward?
Yeah, let's overview them briefly, and then I'm
Okay.
going to get a kind of a temperature check from members of the commission to see if there's any strong opposition to any of the proposals.
Okay, I think that makes great sense. Okay, hold on. Okay, so I'm gonna just go through. So everyone see my screen okay? Okay, here we go. Let's open. Okay, all right, great. Okay, so let's see. So here, okay. So the way when we staff reviewed these comments was we thought in terms of the recommendations the body has already adopted. And the way we identified comments and that could potentially result in new resolutions or recommendations was, you know, whether or not some of these comments were really aligned with ideas and thinking and motivation that prompted all of your recommendations already adopted. So here's one comment that stood out to us. It said, it may be worth allowing disciplined attorneys to resign without charges pending after they satisfy all of their disciplinary requirements on the condition that their state bar website profile is expunged. This would accomplish OCTC's goal of preventing disciplined attorneys from ever practicing again, and the disciplined attorney's privacy interests and their ability to succeed in a different career. So again, this was something that we thought was an interesting comment because, you know, it addresses people's concerns with, you know, the fact that the website, you know, preventing people from, you know, getting work, et cetera, et cetera. So anyway, this is just one comment that, like I said, we escalated to you both. And one idea would just be like, one option is for you to just adopt such a recommendation, or you ask the Board of Trustees to consider the matter further. But let me just go ahead to the next one.
Hey, Lisa, let me stop you there.
Okay.
I think what would make most sense is for members of the commission to weigh in on each individual item while we go through it.
Okay.
If there's any thoughts that the commission has at this point, understanding that if these do go back before the board for staff to look at further, then staff can look at these comments and give the board direction. And then there will be further public comment periods if any of these items are pursued. So, but just at the outset, any members of the commission have any thoughts on this particular new area? All right, Mr. Moad.
Thank you. I guess I'm a little bit confused as to the suggestion, because if I'm understanding the question correctly, if they have completed their discipline, their probation, et cetera, then they would be entitled to resign without charges pending currently. And I guess the only addition is that we would be expunging their record when they resign. Of course, if they resign without charges pending, there's nothing that would prevent them from coming back. You know, there isn't, it's not a permanent resignation such that would be even equivalent with a disbarment, let alone an actual permanent disbarment. California has the ability to be reinstated after 5 years after a disbarment. So I'm not sure that I understand, but even if I do understand it correctly, I think it really comes down to a parallel with the expungement recommendations as opposed to any real change in the resignation rules. But maybe I'm not understanding correctly.
I see Miss Buffington nodding her head up and down. Did you have a similar comment?
No, thank you, Chairman. I guess I'm just a little confused. Okay, so in order for an attorney to satisfy a discipline requirement, there has to initially be charges filed. Is that correct? So I'm a little confused on how an attorney is going to resign without charges after satisfying discipline requirements. There has to be the initial charge, the evidentiary hearing. Then whatever comes of the evidentiary hearing, discipline requirements or recommendations from OCTC, or for instance, I don't know, completing, not MCLE requirements, some type of educational requirement or going through a certain lawyer assistance program. So once those are satisfied, then we would allow the attorney to resign without charges pending, but we'd have to have charges initially anyway, right? I'm confused on that. I'm confused on it. I don't know if someone can explain it better.
Mr. Moed, do you want to take a stab at that?
Sure, although I profess some confusion as well, but generally, if the charges are not currently pending, meaning that it's been adjudicated through state bar court and discipline has been imposed by the Supreme Court, for example, then that person could then resign sometime later without charges pending, having that discipline be completed, the probation served, the term of suspension served, etc. So then they're just back in active status with nothing else pending, then they could resign without charges pending. But again, I'm not sure that there's a huge distinction here.
So there won't be any history of the initial discipline charge? Is that what I'm hearing after the disciplinary requirements are satisfied?
There would be. I think what it is people that choose to go into a different profession. We've heard from some people, for example, go on to do real estate. People Google their names and then they see on the state bar profile discipline. So what this individual is saying is, if I choose to basically, not engage in the practice of law any longer, would you agree to take down my discipline history from the website?
Which I think leads us back to the discussion of the expungement issue. It's really, in my mind, it's not really an issue with the resignation, it's an issue with the expungement.
All right, thank you, Steve, for that. I think that Ms. Jones was next. All right.
No, thank you. I agreed with the concern about the discipline falling off the record. So it looks like everybody's already addressed that. So thank you very much.
All right, thank you. Ms. Anderson.
Yeah, I'm a little bit confused with this. I mean, is the goal for the recommendation that the person never practice law again? Or is the goal for that as a portion of their discipline? Is that what the goal is? So that they can go into another area and we're supposed to say, okay, if you do this, you'll never practice law again. We're relieved. And now you can go be happy doing something else, which raises a little bit of a concern, because if it was maybe they were defrauding all of their clients by stealing all of their funds, and now they're going to go and do real estate and steal their houses. That causes me a little bit of concern. What is the goal?
Yeah, I think that's certainly something for staff to flesh out for the board, and for the board in their larger discussion about expungement and what role the state bar plays, in what information is shared after discipline is has been worked out, after certain amounts of time have passed. I think those are all part of that same discussion. But yes, I think certainly some interesting issues to flesh out if we go down like what sounds like from Steve's comments, a kind of a very narrow distinction. Let's see, I think Mr. Lear was next.
I'm also a little bit confused, and maybe somebody can help me with this, but the way that I read it, and I didn't study it, was that if you resign with charges pending and then satisfy your disciplinary or / probation conditions, then you would be eligible for an expungement and not be on the membership record. That makes no sense just on the face of it. And again, maybe I misunderstood it, but when you resign with charges pending, you would not be put on probation or have any other conditions attributed to you. You're just done. And so the carrot, which is getting your name off the membership record by satisfying X conditions, doesn't work in this model. I'm in favor generally of anything that encourages expungement. And to the extent that you have to earn your expungement, I'd be open to considering that. But I think that the way that the model is stated with respect to satisfying your probationary conditions or whatever through the resignation, that it's not the way the system presently works. And again, if I misunderstood that, somebody can let me know, but that's how I understood it. Thank you.
All right. Those comments sound consistent with Steve's concerns as well. Mr. Larkin.
I'm not going to echo everything said, but I took it to be a sequence issue, that there's no charges pending because the prior matter had been resolved through adjudication and satisfying conditions, and this was a later action. I was not in favor of the expungement and discipline removal presentations when we met a while back, but I can see there is a thread across the country where for lower level matters, I assume, well, I don't know enough about California procedure, but there is permanent retirement where lawyers can retire and underlying active investigations, not of the worst sort, essentially go away, and the lawyer is shown on most bar websites as being permanently retired or retired. There's that dignity piece, which I think we're chasing here, and it would be worth probably staff having a little more time to unwrap all this.
Yeah, absolutely. I think the dignity piece is an important one. I know several of the members of this commission have really advocated quite well regarding members of our profession who are at the end of their career and wish to retire with that dignity. So I think certainly we can continue to look at that. So Lisa, if you could just make a note of that, and kind of just to kind of wrap this piece up, based upon the comments, it does not sound like there is an appetite for this group to put this recommendation forward. Would that be, anybody have any strong objections to that statement? So staff, I'll continue to talk with staff to see if there is a narrow exception that this might apply to. And if it's worth pursuing, then we'll certainly bring that before the board and then put it out for public comment at a later date. All right, let's move on to the next new proposal.
Terrific. Can you see my screen now? Okay.
Yes.
So here is a comment that's one as follows. It may be worth considering a change to the State Bar website whereby Google cannot index attorney profile pages. Consistent with every other licensed profession in California, this provides at least some measure of privacy for respondents. So this speaks to the issue where many public comments we received throughout the commission where people said, my name is Googled and my 10-year discipline appears and this impacts my ability to get new work, etc. And so staff reached out to the Medical Board of California to learn more about how their license verification webpage works. I did a little experiment where I looked at my neighbor, who I know is an active attorney. I did an active medical doctor, sorry. And I did a little search, and sure enough, his name profile under this license verification webpage, which is actually managed by DCA, the Department of Consumer Affairs, did not appear. So I reached out to staff to learn more from the MBC and learned that this was an email that I received from DCA. Because I told them that asked them a very straightforward question. Do you set it so up that I can't find someone that their name doesn't appear in a Google search, etc. And this was their response. DCA search, which I believe is the way you search for something, has been actively configured and designed for performance, security, and status integrity. These configure choices may preclude search engines from indexing the platform. So I thought that was interesting. So because I asked them very straightforward, did you purposely index the platform so that a physician's name profile doesn't pop up during Google search? And that's the response. And so one option for recommendation is if you're interested, if this seems appealing to the group, is to recommend that the State Bar configures the State Bar attorney profile search function to preclude search engines from indexing the attorney profiles. Now I'll just have y'all have a discussion.
Turn it back over to the group. Anybody have any comments one way or the other on this new area
Or questions?
or questions?
Mhm.
All right, Mr. Larkin.
I just say it works. We preclude search engines from indexing portions of our site, but not as broadly as your fellow regulators in California. We found that some of our written decisions had so much data in it that it embarrassed some people, including lawyers, but also witnesses. So we completely blocked that particular access through the search engine crawling sites. It works, it's effective, but I really enjoyed hearing about the broader suggestion to make it such that no one could get a profile even without coming to your site. And I had a discussion with the Massachusetts folks a couple of years back. They didn't like to interrupt the crawling. They thought consumers should have a right to get at it through Google, etc. We took a different view. So I just share that information. It works, we use it, but we don't use it as extensively as you're thinking of using it.
Okay, good thoughts. Ms. Bell.
So yeah, I guess I just want to make sure I'm understanding. So are we saying that a person could search the State Bar website, look under the attorney search function, find this person and see that there's discipline, but yet if they just simply didn't know how to do that and they used Google to try to find out information, they wouldn't be able to find the information? I'm just, first of all, is that my understanding correct?
I think I'm following where you're going with that. So you're saying, let's say an individual doesn't know what the State Bar website is, but they know they have a lawyer, potential lawyer, and so they Google Brandon Stallings attorney. The way our website is currently set up is my name would pop up. There would be a link to my State Bar profile. If we were to go with this proposal, then the State Bar website would not be indexed, and so the Google search would not reveal that I'm a licensee through the State Bar of California. So that's my understanding with the way things currently are.
So yeah, I guess with that in mind, I guess I feel like I'm not sure how that's consistent with our duty to protect the public, and why is there information that only some people can find or make it hard for people to find it? It just seems wrong. I don't know I don't know how to articulate it better than that. It just seems strange, like we're hiding this information, even though I'm all for our recommendations. And I'm actually really supportive of all of our recommendations, including expungement. So if we're going to, so but on this one, I doesn't seem right to me. And it doesn't seem right to me that people can't find that about physicians either. If the boards have that authority to discipline, then that should be something that the public can find easily, not by some kind of like they have to know how to do it. So that's just my thought.
All right, no, some good thoughts. Mr. Fortescue, I think you're next.
Just to kind of follow up on that as well, I'm just trying to parse the language that we received from the DCA. It seems to me that they're indicating that that if that is happening, if the indexing of the doctor profiles is happening, that wasn't their intention necessarily, that they were configuring and designing their website with performance, security, and status integrity in mind, and that these configuration choices may preclude search engines, but they seem to be indicating, and at least in that quote, that that wasn't their intention, and that they may not even have been aware of that was true. And I was just wondering, Lisa, did we have any follow-up conversations with them about that, just to clarify if that's what they were trying to convey?
No, not yet.
Okay, and I think if this does go forward, that's certainly something that staff can inquire about further. Ms. Buffington.
Thank you, Chairman. Oh, okay, so those that have not been publicly reprimanded, so when folks Google attorney names, the profiles will still pop up when attorney names are Googled, right? As opposed to those that have been publicly reprimanded, like someone at the state bar gonna figure out who's gonna parse through, you know, how to get this system implemented? Because this may sound selfish. I mean, I still want my name to pop up. I mean, but I'm a government attorney and I haven't been subject to any disciplinary charges. But when folks Google my name, I still want my name to pop up. But for folks that have been, it's not about me, but for folks that have been publicly reprimanded, so how is the state bar going to differentiate when the profile pops up and when it doesn't pop up?
I think based upon Mr. Larkin's comments about the way other jurisdictions handle this, there might be ways to wall off certain aspects of the attorney profile, such as if there's a written opinion about discipline, you know, that the opinion contains names of witnesses, you might want to protect their privacy. So I'm certainly not a tech person, but I think that we can talk to the techie people and figure that out. So that parsing out would certainly be a part of any recommendation, you know, coming from the Board of Trustees and going out for public comment, just about what specific information would then be subject to those search engines.
Thank you. I understand. Thank you.
All right, Mr. Lear.
Yeah, I just wanted to bring up the situation that happened many years ago with a client of mine who would feel very strongly about this issue. And that is one where he had 17 charges alleged against him and a notice of disciplinary charges. We ultimately went to trial, had all the charges dismissed, but for a year, he had an NDC on his membership record. And so if you Googled his name, potentially through a referral to him, you would see that NDC. And in the world of attorney discipline, when there's an NDC, the presumption is guilt over innocence. And so in that year, he later told me that he lost $100,000 worth of income that he attributed to the NDC with charges that ultimately were not meritorious being online. So he would be somebody that feels strongly that when you Googled his name, that he would not want the state bar membership record to appear first, which is, I think, generally the way that it works. And so that's a situation where it would benefit him. This rule or this proposal would benefit him greatly. So that's one comment that I have generally. And then secondly, insofar as second chances and whatnot, what's happening now, as I understand it, is if you were to Google an attorney's name because of some kind of marketing effort or referral or whatever else, that the state bar membership record comes up first. So even if that discipline is 5 or 10 years old and the attorney has been rehabilitated and is doing great, that attorney would nevertheless suffer from the record discipline, which admittedly is still public, but it would be the first Google result is my experience and my understanding, and would be a great disadvantage to that attorney, despite the fact that that attorney has done a great job of rehabilitating. So for that reason, I would support the proposal, which is to not have that discipline record be the first in terms of the Google research result. Thank you.
All right, so just kind of just to get a temperature of the group, it seems like there is some appetite for this proposal. Certainly there's issues that members of the commission have raised that need to be discussed and fleshed out, but is there any strong opposition to passing this along to the Board of Trustees for potential referral to staff for further work? Oh, I see a couple more hands. Ms. Good.
Yeah, I oppose it. I mean, I think I understand that there may be cases where we might want to do it, but it's too hard to adjudicate which ones where it would be appropriate versus which ones where it would be inappropriate. So I don't support this change. And so just wanted to put that out there.
All right, Ms. Schneider.
Yes, thank you. I'm also opposed. I think that the information should be available to the public that is on the State Bar's website. If something has been expunged, it's no longer available, then it should be obtainable. But if something is, currently active on the board's website, it should be easily obtainable by people, members of the public, so that they can make informed decisions. Thank you.
Okay, so certainly voices in opposition, any in support of passing this on to the board? Okay. Gonna call this one. Okay, Mr. Lear has his hand raised. Is that in support of your, okay, Ms. Buffington? I'm gonna call this a tie, and tie goes to maybe fleshing this out a little bit more fully. And so just make a note that there was a split of opinions on this, and it might further or might benefit from further work from staff. All right, anything else on this piece before we move on? All right, Ms. Chavez, go on to our next piece, please.
Okay, so okay, all right. So here's another comment having to do with creating timelines for a specific group of attorneys. In particular, these are attorneys who were reinstated after they resigned. Here's a comment, 2 comments. There needs to be a similar timeline for removal of the attorney discipline from the website attorney profile page of, quote, attorneys who submitted a voluntary resignation with charges pending, who have subsequently been reinstated on the active roster of the California State Bar. Note, I am such an attorney who resigned in 1994, quote, while charges were pending, unquote. And though my petition for reinstatement was granted in 2003, and though I've been practicing since without any discipline, my State Bar profile website profile on many occasions have caused me hardships. Despite not having been disciplined, many have viewed my profile on the bar's website and had incorrectly surmised that I was disciplined and consequently disbarred. And then another comment was, there needs to be a category for voluntary resignation with charges pending who have subsequently been reinstated on the active roster, and attorneys who have maintained a discipline-free law practice of 5 years or more after reinstatement. They should be eligible to have their attorney discipline record expunged. So these are just like having to do with removal of website, of discipline history, and expungement of records for attorneys who resigned with charges pending, but were ultimately reinstated. And so just a little bit of background on what it means for reinstatement. So attorneys may petition for reinstatement after disbarment or resignation. And these are the four, when they fill out an application on the State Bar Court's website, there's one of 4 categories that they have to indicate their status. They're petitioning for reinstatement because they were previously disbarred. They had resigned with disciplinary charges pending. They resigned without disciplinary charges pending, or they were intermittently suspended or enrolled inactive immediately preceding a disbarment or resignation. There are a bunch of requirements listed here, and they also have to pay $1,600 for the State Bar Court to consider their reinstatement. Okay.
All right. Any questions or comments for staff? I see Ms. Nikau has her hand raised.
I'm sorry, that was my error. I apologize.
Okay, no worries. Any thoughts or comments on the proposal? Steve, kind of looking at you as someone who lives in this world, any initial thoughts?
Well, thank you for calling on me, Trustee Stallings. I mean, I think it essentially boils down to the same expungement issue as before. I mean, one could nitpick a little bit, I mean, certainly the person was not disciplined, but and I haven't personally handled these, but my understanding is that there is a stipulation as to facts and conclusions of law as to the violations prior to the agreement or opinion, the recommendation that the person should be allowed to resign with charges pending. Now, that may not have been, for example, when this particular commenter went through the process, because I think that process has changed since then, but that's the situation now. And in essence, there were violations, but that for certain reasons, the State Bar Court and the Supreme Court believe that it's appropriate to let this person resign without going through that discipline process. So in that sense, there are violations or a violation, and then it comes back to the expungement issue. And if this commission feels that it's appropriate to have things be expunged, then we just have to figure out whether it's appropriate to have this expunged as well. I'm not sure we have decided that it's not appropriate for disbarment. It's not a disbarment. A resignation with charges pending is not a disbarment, although it may be that disbarment was pending or something along those lines that led the person to want to resign in the first place, but not always.
So would this issue be so inextricably intertwined with the expungement issue that we could include it as a discussion item within that broader expungement recommendation?
Are you asking me particularly?
Yes.
Yes, I mean, I think the board can and should consider all of those things as part of its decision on the expungement issue.
All right, any members have any differing opinion or viewpoint as to what Steve just talked about? So I think, Lisa, let's put this as a potential aspect to be discussed in the broader expungement issue. If there's a substantive change, though, it would have to go back out for public comment. So we'll just have to look at whether or not that would be required.
Are you suggesting that maybe instead of it being a recommendation from this group, it would just be like added to like the text in the report?
It would be a
another
discussion.
item?
Yeah, it'd be a discussion piece as opposed to a recommendation.
Okay.
Well, I think it is an expansion or a clarification of the existing expungement recommendation if that goes forward. So I don't think it's like a staff recommendation. I think we understand the directive, Brandon, and what you want to achieve. So we can get that done. But I think it's just another aspect of the broader topic of expungement, which what happens to individuals who get reinstated. Shanae had asked for an overview of the expungement recommendation. I think we will get there. I don't know, Lisa, if you have a slide that shows just what the group has did recommend on expungement. What went out for public comment?
Thank you, Executive Director Wilson. Thank you.
No, I don't, but can I just take a moment and look?
Interrupt the process. So Brandon, whatever order you want to go in with these, but at some point we could pull up the expungement recommendation that went out for public comment.
Yeah, I would. So we're going to handle that at the end of the meeting. If we could, or not the end, but I think we're going to walk through the individual areas to see if any members had any input based upon public comment. So I think it makes sense to do it at that point.
Okay, should we move
Okay.
on to the next recommendation?
Yes.
Yes, okay. Go to the next slide here. Okay, so another recommendation that it has to do with websites. It says require attorneys to provide notice of regulation by the state bar. And here's the comment. We would encourage the state bar to find ways to inform more people of their abilities to file complaints. For example, the state bar could look to the medical board's policy that requires all medical board licensees to have a physical notice in the office that provides information about how to file a complaint with the medical board. Something similar could be implemented for California attorneys so that both clients and other staff who observe malpractice or other action that warrants disciplines have information about and can feel empowered to make a complaint. This is particularly important for complainants who are not traditionally empowered to speak up against people with more social and financial leverage, as attorneys often are. So we did a little research on the medical board's policy and learned that there is regulation that requires all medical licensees, quote, to provide notice to each patient of the fact that the licensee is licensed and regulated by the board. And it goes on to say the notice shall be provided either by posting the notice in an area on the premises that is visible to the patient, a written statement that is signed by the patient, or including the statement on letterhead. The notice shall include the following. And so here's the notice that that has to be made available to patients. And this information is available on the Medical Board of California's website for licensees to follow. Okay. So just, that we staff could consider two recommendations. One could be like a very straightforward one that we require attorneys to provide notice of regulation, which is similar to what is required of California medical licensees. But another recommendation is to just take the time for staff to explore the implications of doing so, and also to consider the fact that the legal profession has different modes of service than with the medical profession. A lot of it is on the phone, a lot of it's online, and so to consider those nuances, if ultimately that is the goal we're striving for, that such a requirement would have to consider these different modes of service.
Okay. Any questions for staff or comments upon this potential area? Yes, Ms. Anderson.
Is there a lack of reporting? I mean, I'm just confused as to why there seems to be a need to generate more consumer complaints. Is there a feeling that people don't know how to make complaints against attorneys? Or is there a perception that there aren't enough complaints generated? And where are we getting the information or the statistics that attorneys, that the public isn't making enough complaints about attorneys? I mean, are we looking for a problem? Is this a solution looking for a problem? I don't understand why we're addressing this issue.
I think certainly as a public protection agency, we want to make sure that there's adequate access to the discipline process and discipline system. And so notices such as this might aid in that, further, just further steps of educating the public, making sure that they know what is available to them. So I think it might be hard to tell in the negative whether or not someone had a complaint and just didn't know how to file it, and then they abandoned the complaint. So I know we certainly go through steps, or staff goes through steps to look at the call center, whether or not complaints are started, whether they're abandoned based upon wait times. We track a bunch of different metrics within the discipline system, but this one, I don't know if we would be able to track. So that's kind of my initial thoughts. Miss Good.
Yeah, I mean, I'm all for accessibility, right? And for people getting information about how to file complaints. Clearly, that should be a goal of the bar, and I'm all for it. I just question if this notice concept is really going to result in getting more information into the hands of consumers. In a patient doctor relationship, the person often goes into the office. And somebody just noted a lot of our stuff is done online, over the phone. Where would we post it? Like, what would that look like? I just can't, as a practical matter, I don't think that this will accomplish what it's meant to accomplish. I mean, maybe a better idea might be, for example, mandating that this be disclosed in engagement letters with clients, right? Maybe that's a better idea in terms of making sure that information goes to clients about this fact that attorneys and their firms are regulated by the state bar. So that would, so that's kind of my comment. I don't think that this is going to accomplish what it's meant to accomplish. And if we think there's a lack of information out there, it could be better addressed in some other way, such as an engagement letter, disclosure, or something along those lines.
Or on the website, maybe. An attorney's website.
Miss Buffington.
Yes. We already have on the State Bar website is a banner that says file a complaint against an attorney. So if we're going to require attorneys to provide this notice to potential clients, who's going to monitor that? Attorney compliance. It seems impractical, especially given our electronic age, everything is kind of done online. I mean, I'm old school. I like to see things in black and white on paper, but just with the new technology age. Thank you.
All right, it's good comments. Miss Mayorga.
Thank you. Yeah, I echo everything that Ms. Good and Ms. Buffington said. I think coming from a criminal law perspective, I'm a public defender, and I think this would be way too difficult to implement, especially with our clientele. I think if anything, one idea could be maybe notices the court can put up. So we'd have courts put up this notice like around courthouses. I think might be a little bit more efficient to get the word out. But I agree. I think the website is enough. But if we wanted something additional, that's an idea.
All right, Miss King.
Hi. My point of view from the public is I think it's very simple to go online and do a quick search on how to file a complaint and it pops up. I don't think it's worthwhile. I'd rather see the recommendations implemented or suggested by the Farkas report and those ideas and be more preventative than focusing on adding an extra item on the paperwork. Thank you.
Okay. All right. So far, I don't think I've heard any support for this or overwhelming support. So anybody wish to make a case for this item? All right. Thank you for your feedback. We will probably not include this going forward. All right. Ms. Chavez.
Let's see where I'm at. I think this is the last one. It's to do with timelines. Oops. Okay, there we go. It has to do with timelines again. Like it's, if you remember this, those two items with regard to timelines have received the most votes for agree if modified. So here's an example of a modification requested. I've been practicing for over 40 years. The first year, my dues were late due to mailing address change from LA County to Orange County. Thereafter, from death in my family due to another move, extreme upsets in my personal lives. For the subsequent 39 or so years, my dues have always been timely. I have committed no further wrongs in sight of the State Bar. Although these rule changes state they are intended to address, quote, disciplinary matters, there is no discipline, no reproval, no probation, no disbarment, only briefly suspended until my dues were received. The rule should address, quote, suspensions for failure to pay dues in timely manner, quote, in the same manner, but with lesser consequence. And last but not least, I thereby request my suspensions expunged in full. I believe a 30-year, 8-year penalty is sufficient, even if consecutive. Thank you. And so just a really reminder, we talked about administrative suspensions in the discussion about expungement, because we actually do have two mechanisms by which attorneys may receive administrative suspension. And this is basically if they're ineligible to practice law in California for the following reasons. If they fail to comply with their MCLE requirements, or they fail to pay their fees. And so as we shared during the discussion, there are avenues according to these two rules of courts. But I looked into a little bit further and I learned that it's actually, you can ask for expungement on a one-time basis. And of course, you have to meet certain requirements. So I'm not sure if we shared that detail earlier on in our discussions, but there are avenues for expungement, but it's a one-time basis for either one of these reasons for having an administrative suspension. Okay. So the commenter is saying that right now, if you look at our recommendations, it has to do with discipline. We've created timelines for discipline, and she's saying that this is an administrative suspension, and she was considering a timeline for those who have this. So even though, I think, so for this group to consider, so even though people who have administrative suspensions have a mechanism to petition, what she's saying is add it to the automatic expungement, automatic removal of discipline history that was already adopted for disciplines.
So is there any appetite, or are there any questions for Ms. Chavez? All right, Mr. Larkin.
Well, I agree with the goal of this particular suggestion, though I don't agree with basically with expungement or taking things off the website that are disciplined. I wonder whether it might be worth thinking of this differently. Not all states call this a suspension. In our state, we happen to call a removal from the role of those authorized. And we don't give history on the website of prior removals. Regardless of how it would be done, it doesn't seem like there's a public protection need to disclose any lengthy history of prior suspensions or removals, whatever the term is. So I think this is another area where the California Bar could get more friendly with lawyers without causing any harm to the public.
Okay. Mr. Buenaventura.
Yes, thank you, Chairman Stallings. I actually do very much agree with the sentiment expressed by this opinion. We don't have a debtor's prison in the United States. And so to discipline someone for their failure to pay dues, I think it's wrong. And I think that when people can't afford to pay the fees to engage in the profession, that doesn't sound like conduct that's, you should be getting disciplined for your failure to pay your fees. So I do agree in removing this category under the disciplinary system to not make any mention that this is a disciplinary finding of any sort because you can't pay the fees. And then the question I also do have is there a sort of a forgiveness plan or a way for an attorney who cannot afford to pay the fees to practice law, that they can apply for some kind of stay or forgiveness or something, so that it doesn't bar them from practicing if they can't afford to pay the fees. Thank you. That's my question.
All right. Just if, again, want to remind everybody, if you're not talking, if you just mute your microphone to avoid any audio pollution. Mr. Buenaventura, if I understand your question correctly, I think I can answer a portion of it. For the yearly dues, there is a provision where if a lawyer doesn't earn a certain amount of money, then dues can be reduced pursuant to several different levels. I sat on that committee for a while where we would review various applications, basically appeals to the board for some sort of economic hardship. So you would have certain levels. If you didn't make that amount of money, then you could pay a certain amount of dues. And then if there were any economic hardships, then there's also an appeal process to have the board waive certain dues as well as late fees. So.
Thank you. That's very helpful.
So we do have that. All right. I think Mr. Buenaventura, were there any other questions you had? I'm sorry.
Not question, just the comment that I think this should be removed from a failure to pay your fee as a disciplinary issue. Thank you.
Okay. Thank you. I think Ms. Pansky was next.
Thank you. First of all, I apologize for the background noise. I'm juggling different obligations today, so sorry. I just want to say that it's not just a question of financial inability or perhaps a need to delay the annual dues payment, but oftentimes the failure to comply with the MCLE is fairly minimal, where somebody may be short, a few units. They have to search for their records and provide them to the bar, or occasionally, make up units. And normally the system does permit a lawyer to do that and, and cure the deficiency. It's, I think, already identified by the state bar as an administrative, I can't remember the exact term, but an administrative inactive status or administrative inability to practice, as opposed to suspension. But the rule already exists to permit, excuse me, these administrative inactive status matters to be expunged. I don't see any reason to limit it to one. And so I would support a recommendation that the rule be changed to delete the limitation on the number of administrative inactive status proceedings. And that would cure the problem. Thank you.
All right, Mr. Moad.
Thank you. Yeah, I echo Ms. Pansy's comments that they're not a discipline. They're not on the website as a discipline. They are an administrative movement to involuntary inactive as a result of the failure to pay or the failure to report MCLE. I can't say, certainly not to the extent that Ms. Pansky can, about the extent of the MCLE violations, for instance. I can tell you that the movement to involuntary inactive is not immediate. For example, the due date for filing of MCLE is February 1st. I believe that it's June 30th that the state bar finally moves somebody to involuntary inactive if they have not reported their MCLE. So they have, not only do they know for 3 years that it's coming, but also they have from February to the end of June to report it if they haven't done so already. Now, that's not to say that I disagree with Ms. Pansky. But I did want to make sure that that was clear in everyone's mind. We can certainly, and I think maybe without it coming from this commission, we can certainly reevaluate those rules. That is part of our regulatory function and happens to fall within the division that I am currently heading up. And I'd be happy to take a look at those rules, because I do think it would make sense that while a current suspension for a violation of one of those things should certainly be posted as an explanation of why they are currently inactive, that certainly far distant history for those types of conduct may not be necessary to include on there.
All right, thank you, Steve. Mr. Buenaventura, did you have a further comment?
Yes, so if the failure to pay the fees is not considered a disciplinary type action, then I would suggest that at the very least, we take out, if it's going to go down on the books per se as suspended for failure to pay fees, that there's no need to have a record that that's the reason for the suspension. For someone not being able to pay fees. And why can't we have a situation where that the person just on the record says that they're inactive? Why does there have to be a reason to state why they're inactive? Because I don't think it's fair to have an attorney's record show that their inability to pay fees, and we don't know what the reasons are, but I don't think that that should be part of the record as to why they were administratively suspended because they didn't pay their fees. I think it's okay for an attorney to just remain inactive, and I'm not really sure why we need to go down that road in terms of explaining why they're inactive. Thank you.
Mr. Moad, did you have a response?
Maybe, I'm sorry, Brandon, but maybe it sounds like what we could do is just direct staff to come up with some recommendations around administrative suspensions generally. Because it certainly makes sense if we're going to be taking other things off the website that are disciplinary, that we might consider removal of non-disciplinary indications on the website.
No, it certainly seems like there's appetite for this area. So any other comments, brief comments? Recognize we still have some work to do. Mr. Lear.
A quick comment, and this is I agreed with most of what Ray said, but I would ask Ray to consider that an administrative suspension for failure to pay dues is potentially a better description than administrative suspension with no explanation, simply because consumers and maybe many of us on this Zoom would jump to a worse conclusion, i.e., oh, he or she must have stolen some money. Even though that's not consistent with administrative suspension, people that are less informed could jump to that conclusion. So a little bit of pushback, but otherwise I agree with Ray.
All right, thank you. All right, we will refer this then to staff for further. Yes, Ms. Chavez.
There's a comment from Ms. Schwinn, Mr.
Yes.
Shardy.
As a member of the public, I agree with Mr. Lear. I think that it's better to put in the reason than just say administrative suspension. Because, as a member of the public, if I saw that, I would think, what's going on? But if there is a description and it says that it's because of the failure to pay the dues, then I would know what it is about.
Thank you. All right. We look forward to briefing this a little bit more in depth. Okay, Ms. Chavez, were there any other new recommendations?
No.
All right. So now I think we move into a discussion on the ad hoc recommendations that have been previously voted on. Lisa, was there a portion of your presentation that dealt with that?
Yes, there was just, let me just share my screen. So again, another option is to modify recommendations based on the public comment received. When staff reviewed all comments, we didn't see anything that stood out to us that would merit a modification. That said, if you all read those comments, this is your opportunity to raise those potential modifications. The only thing that we noticed was these following comments. And it had to do with clarifying eligibility for removal of discipline history from the website and expungement. So this wasn't part of the recommendation. However, in at least 2 places in the text, we discussed this body's ideas on or recommendations or thoughts on it. It's not recommendations, it's just eligibility guidelines that we put in the text. Here's the comment. With respect to attorney discipline on State Bar website /expungement, I am unclear as to the meaning of the statement. Both proposals recommend that eligibility for removal of discipline history from the website be conditioned upon no new discipline or active investigations during this period and payment of all restitutions, unquote. I'm unclear as to what is meant by the phrase during this period. What is the period? Also, I am unclear what the meaning of quote active investigations means. What period of time? Would those include complaints that were investigated and closed by the California State Bar with no action? So that's comment number 1. Comment number 2 was, what does active investigation mean? I think it should be clear, only complaints that led to filing of bar violation charges should stop eligibility. So here's an example of where we discuss eligibility in the report. And what I have here is in what I think would be my understanding of what this body meant when it talked about new discipline, et cetera, and active investigations. And so this is, so the comments in red are my additions to this text, and I have one word crossed out. So it would be eligibility for removal of discipline history and expungement of the attorney record would be based on no new discipline imposed during the relevant time frame, no current active investigations, and payment of all restitution. So then it's really clear that whatever it has to do with, so if the time frame for something being considered was 3 years, during that last 3 years, there was no new discipline imposed. At the time of the time frame is they're ready to be considered for removal of a website expungement, at that time, there is no current active investigation, and that there's been payment of all restitution. So this is my attempt to clarify this language of eligibility, but I would love to hear what others have to say. And I would recommend, staff recommends that we clarify this eligibility rules.
All right. Any comments or questions? Lisa, could you switch to the grid look? Hopefully everybody had enough time to review that language. Any opposition to staff's clarification? Okay. All right, seeing nothing. Okay, Lisa, what's the next item?
Now it's open to any members who want to propose new recommendations or modifications to current recommendations based on public comment received.
All right, so anybody want to make any further recommendations based upon public comments? Any changes to items based upon public comments? Anything of that nature? Give everybody an opportunity. All right, so Lisa, I know we talked about a resolution, and I guess this relates back to the new areas. Do we want to put that up on the board or up on the Zoom?
Yes. So, okay, so before we do this, I found the slide that summarizes the timeframes for expungement. That's what Ms. Buffington.
I'm sorry.
Review? Yes?
Yes.
Okay. Okay, okay. So these are the timeframes that we adopted. These have to do with, we make it clear that it's both for expungement of the discipline record and removal from the website. As you can see, it's this is discipline. And yeah. These are the different types of disciplines, and these are the proposed timeframes.
Ms. Buffington, did you have any questions about this particular recommendation in light of public comment or on any of the new recommendations?
No, I'm very clear on the proposed timeframes. Have we come up with what type of disciplinary charges will be expunged?
Lisa, I think that's for you, like what discipline history is going to be taken down? I thought it was everything except a disbarment.
Yes, so Ms. Buffington, is your question with regards to the recommendations that already been adopted, or what we've talked about today?
I think all, just so I can understand.
Okay. So my
Thank you.
understanding is that nothing is excluded. There's nothing excluded based on charges. And everything can be expunged except for if you were disbarred. So it has to do with the type of discipline imposed rather than charges.
And I don't think anything today changed that.
Right.
Anything we discussed today.
All right. Ms. Buffington, did you have any other questions or concerns in that area?
So thank you, Chairman Stalling. So who's going to determine what can be expunged and what cannot be expunged?
I'm a little confused by the question because it was in what was put out for public comment. It was basically everything but a disbarment, but there were certain conditions, like if you hadn't had a new complaint, etc., after certain timeframes. On the disciplinary side, today we've talked about administrative, non-disciplinary suspensions, and some other things, but it wasn't sort of a case-by-case basis what kind of discipline can be expunged.
Oh, okay, so thank you, Executive Director Wilson. So when someone makes an application or applies to have the record expunged, if certain conditions are met, it'll be expunged. Is that what I'm hearing?
There would be an application for it to be expunged.
Under the proposal.
Yes.
Yeah.
Okay, and then who's reviewing that application?
Well, Lisa, maybe you can clarify, is the proposal for an application or automatic expungement if certain criteria are met?
Thank you.
It's all automatic. It's all automatic. And that's removal of discipline history and expungement, as long as the eligibility has been met.
Any other comments on expungement? All right, any other comments on any of the other recommendations? And so goes through the cost and sanctions assessment, the ENEC conference, moral turpitude, progressive discipline, attorney representation. And again, not saying that anybody needs to make comment about that, but just kind of going through the different areas that we have made recommendations in. This is great. I think this really speaks to the work of this commission and to the work of staff to really distill the thoughts of this commission. And certainly that there have been areas where there has not been a complete agreement, but I think that the process has really turned out a really good work product and one that this commission can be proud of. Going up before the board, I think certainly the diverse views of every member have been captured in the report. And I just really applaud the work of this commission. I think before we close things out, though, I do want to get to the resolution in regards to the new areas. Lisa, did you have that language?
I do, but before we talk to, I share that, let me just share with you all what the next steps are, and it'll give you context for the resolution. Okay, so as I said in the beginning, we need to issue an updated report. And so the updated report that's going to be due to the board in January will include updated text with the ideas discussed today, add updated text with regards to eligibility. We'll also add the staff memo and also the report with all the public comments. And so we'll distribute the report to all members by Tuesday, December 20th. Please get to me your technical and clarifying edits by Tuesday, January 3rd. Oh, that should be 2023. Excuse me. And then at the same time, you can write if you still have any written dissents to new ideas. You can submit those to me then too. But let me just share my screen when we're sorry. Okay. And so here's a resolution to consider. We had a similar resolution to this the last time when it came down to staff pulling together the final report. And that is that you're going to approve, the ad hoc commission approves the commission's final report, allowing edits pursuant to discussions held and recommendations adopted during its December 5th, 2022 meeting, as well as clarifying and correcting edits by staff and commission members. So what this means is that I will carefully review this meeting's recording. I will capture all the places where we said that we were just like, this is a no-go, this is a yes, let's add this to the report as an idea, as an additional element to this recommendation, etc. I'll attach, and then I'll do what I said we do, which is attach a staff memo and attach the report of all the public comments, and then I will share that with you all. So, and I will flag the areas that the report has been updated, and then you can then give me any clarifying and correcting edits. But that we won't need to convene again because you're ultimately approving the report, knowing that I will be adding these edits pursuant to the discussions from today. And we can add, and we can modify this resolution as you see fit.
All right, that is the resolution then for the commission. Are there any questions or comments? All right, if there are none, can I have a motion?
So moved.
First by Mr. Larkin, is there a second?
Second.
All right, second by Ms. Bell. All right, Ms. Chavez, can you go through the roll, please?
Yes, and I want to acknowledge that several members have joined us, and some I've already noted their attendance in the attendance roll. Okay, since we started, okay, Anderson.
Present.
All right,
Ms. Anderson, we're voting on the resolution that's there on the screen. Great, thank you.
Thank you. Bell,
Yes.
Buenaventura,
Aye.
Buffington,
Yes.
Chen, Duran, absent. Chen is also remains absent. Rashadi,
Yes.
Mr. Farwell. He's here.
I think I saw him leave.
Oh, okay, thank you. Good.
Aye.
Jones. Jenna Jones. Looks like she left. Joseph.
Yes.
Jenna King.
Yes.
Jerry Larkin.
Yes.
Okay. Melanie Lawrence is absent. Edward Lear.
Yes.
Alexia Moraga.
Yes.
Judge McGill. Did he end up joining us? No, he did not. Steve Moed.
Yes.
Cynthia Nakau.
Yes.
Ellen Pansky.
Yes.
Eloise Rosenblatt. Saw Eloise join us? Maybe she left. Okay. Linda Schneider.
Yes.
Sean Saleg.
Yes.
Okay. Sean Saleg. He's perfect. Sean Saleg. He remains absent. Judge Wang? Looks as though Judge Wang? Okay, and Martin Winfield. Okay, the resolution passes with 15 yeses.
All right, excellent. Then Lisa, we had prepared another resolution regarding the new items. I think, do you have that?
Is it necessary?
No, the way that we wrote this one, we wrote it so we're gonna
Okay.
capture all of the ideas that we discussed here.
Perfect.
Yes. So they won't
All right.
be new recommendations, they'll be like written up in a narrative that says this is what's discussed and we, yes. Mhm.
Excellent. All right, well, thank you everyone for your work on this commission. I know it's been a work of love, a work of endurance. It's definitely been a marathon and an ultra marathon of sorts going back since November of 2020. So thank you to your dedication and your desire to protect the public, to ensure due process for those in the discipline system, and really just want to call out the excellent work of staff. I know that there are many untold members of the California State Bar who put in a lot of work on the presentations to this body. Steve Moad, definitely for one, and then Justin Ewert, who was our another staff member who put in a significant amount of work, and then Lisa Chavez, who took us to and across the finish line. And of course, Leah Wilson for her excellent input on all these meetings. So thank you to each one of you. You have my personal and sincerest gratitude. And so I really wish you all the best and look forward to seeing you all in other State Bar type meetings. If you have any public comment on any of the items going forward, please do not hesitate to share your thoughts. But we really do thank you for the work, the excellent work product. And as the Board of Trustees reviews it, if we have any further requests for clarification or information, we'll absolutely reach out. So thank you all. And this meeting and commission is adjourned. Thank you all.
Thank you, everyone.
Thank you.
Have a happy holiday and enjoy the rest of the year.
Bye. Thank you.
Bye-bye.